Paragraph 9 defines the default damages. The buyer's default damages are limited to the deposit. So that's what's called liquidated damages, and everything is capped there, even if the seller suffered more damages than your deposit. So on the one hand, you want to have kind of a small deposit so that you don't have a lot to lose. On the other hand, you always have to leave a large enough deposit so that the seller knows that you're committed to the transaction. We often see deposits between $1,000 and 5% of the purchase price. That's usually considered a strong deposit. It's important that you not confuse deposit with down payment. We also don't want to give such a large deposit that we're including our entire down payment, which might be 20% of the purchase price. That would be too far of a loss to take in case something unexpected happened and you're unable to complete the transaction. Sometimes things go really wrong for a buyer and they could lose their job. Something could be really out of their control, and you don't want to leave yourself exposed where you've given more of a deposit than necessary to get your foot in the door with the contract. One of the things that often comes up when buyers see the buyer default damages, they ask, well, what about the seller default damages? Like if the seller fails to go through with the transaction, what are we entitled to? We don't list the seller's default damages. However, the seller's default damages can be far greater than the buyer's default damages, which are again capped at the deposit. If the seller fails to close, you have one of your options. If the seller fails to close, is to go to court and sue for specific performance of the contract. Because land is unique, the seller cannot get away with just paying money damages. You may be entitled to specific performance of the contract so you get that particular piece of land. That is a very powerful remedy that's available to a buyer, and that can be extremely expensive to the seller. Number one, they're going to have to perform. Number two, they're going to be responsible for your attorney's fees. And alternatively, if you don't go for the specific performance, you may be entitled to incidental and consequential damages and the benefit of your bargain damages. These are two different types of damages. So the benefit of your bargain is the difference between the value of the thing that you were buying and the price that you had agreed to pay. So that would be like a profit that you would have made had the transaction gone through. So you would be entitled to that difference. So an easy way to think about that is if the house appraised $30,000 over the sale price, you'd be entitled to that $30,000, for example. Plus, you'd be entitled to all your inspection fees, your appraisal fee, your attorney fees, and there may be other incidental and consequential damages. All your travel, you might have had a job that requires you to move by a certain date into the city that you are buying your property in, and maybe you lost that job because you were not able to fulfill that requirement. You may be entitled to compensation for that loss as well. So imagine the seller's default damages could be far greater than yours. So don't be upset that they're not listed out right here. It's actually better that they're not and left to the common law damages.